Hello, everyone. Thank you for joining us at this Your Overseas Home webinar. My name is Yana Kopova Harris, and I will be hosting this session today. Today, we are discussing the inheritance tax in Spain. It's a very technical topic, and that's why we call this a masterclass. Thank you for joining us today. It's great that you can be here, whether you are with us live or catching us on demand. We are delighted that we can help you to realize your dream of owning a property in Spain. Today's session will be a maximum of 45 minutes, and if you are listening live, there will be plenty of opportunity to put your questions to my guests, Emma Belcom and Christina Gaspar from JLCA and AS Lawyers. If you do wish to ask anything, please type your query into the question tab on the right-hand side of your screen. If you need a reminder of anything discussed today, given it's a very technical topic, or you want to share this with a family or friends, a replay will also be available on Your Overseas Home website in on-demand section. So, without further ado, today we have got Emma and Christina with us. And because it is a very technical and factual topic that we are discussing today, I did ask them to put some simple presentation slides together so that we can get some understanding of the topic. And then I also have several questions to ask them as well. But if you do have questions, please feel free to type them, and I will do my best to answer or ask and answer all of the questions that are being asked today. Emma, Christina, welcome. Thank you for joining us. Tell us a little bit about what JLC and NAS lawyers do, and let's then talk about the inheritance tax.
Thanks very much, Jana. Well, just to begin with, I'll just give it a little bit of a background of our firm. We're JLCA lawyers. We're a Spanish legal firm, purely a Spanish legal firm, so we don't practice British law, and we've been established for over 20 years. We've practiced from Spain, but we also have offices in the UK and the US, and we pride ourselves on being a multilingual office, which means that we have many languages covered from within our offices, meaning that it's not just about translation, it's about interpretation and making sure our clients fully understand the processes. In terms of the firm itself, we do cover all areas of law, extrajudicial, including conveyancing, purchasing, selling, obviously inheritance processes, but also civil and criminal matters. We'd like to discuss today the inheritance process. It's very important to understand, and I'm basing this on the idea of mostly talking to British people, is that the process is so different to what you would be used to in the UK. And it is important to follow the right steps to make sure that you don't have problems later on. Myself and Christina, we've split up the steps. So I'll start with the first ones and I'll pass over to Christina to do the second half. Now, in terms of the inheritance process itself, when somebody passes away, we do, and they have property or assets in Spain, unlike the UK, where you have a process that you don't have to go through a formal probate process, in Spain it is required in order to be able to change the name of the property into the heirs. The reason being that, for example, if you haven't done this process, you wouldn't be able to sell the property or transfer it or do anything else with it. The same applies with bank accounts and investments. So the first step would be to obtain a copy of the death certificate. If they died in Spain, just the actual certificate. If they died outside of Spain, it has to be legalized. Once we have that, then we can apply in Spain for a certificate of the last will and also any life insurance policies that are in place. Again, this is important, irrespective of whether you know that they've got a Spanish will or you don't know, or you know that they don't. You still have to go through this step to have the certificate to say that there is no Spanish will, if that is actually the case. And of course, looking for any life insurance policies can be very helpful towards any possible taxes that might be implied or costs in going through the process itself. Once we've gone through these first stages, we then also need to have an authorized copy of the last will, whether this is going to be the one in Spain, the Spanish will, or whether we have to go through a process, if it's intestate, of having the equivalent that we can then use in Spain. Once we have all of this information, we can then actually go through to the inheritance itself and work out exactly what the estate entails. This would mean obviously any properties, bank accounts, investments, but even things like cars, which somebody might have owned, will need to be transferred to the heirs as well. So we have to have all of this information so that the client then knows what is going to be passed to who and how, and what the process will be from then. Another requirement in Spain is an NIE number. Now, this is something that people are going to be heard about anyway if they're looking at property, because it's a requirement when you purchase a property. It is just an identification number. I suppose the easiest equivalent would be to refer it as your national insurance number that you have in the UK. So it doesn't have any tax implications as such, having the number, but it is referenced for fiscal purposes, purchasing property, purchasing a car. Okay, so if I pass over to Christina to go through the next slide.
Yes. So I'm Christina. I'm a Spanish lawyer here living in London. So basically, the next steps will depend if this is had the will or not. But once all the steps that Emma explains have been done, the next one will be sign the deed of adjudication that basically confirms that all the state, all the years, and all the all the rights that you have from this state are clear. So this deed has to be signed before a notary public, and you have to pay previously all the taxes. What taxes you have to pay? Basically, it will depend of the or where all the assets are based. So if you have any questions regarding this valuation and everything, we could obviously clarify everything by email. So you could contact us after. Once the liquidation of inheritance taxes and the plusvalia has been paid, we will have everything ready to unlock all the assets, all the funds from the bank accounts, and put the properties in the name of the heirs. So that's it. Obviously, this process is different if you have the will or not. So obviously, we always recommend do the will because the process will be easier for the heirs.
Thank you. Thank you both. You have mentioned about the actual paying of the tax. What are the percentages in Spain for the inheritance tax?
It will depend of the area of the assets are. So I don't know if Emma could clarify the different percentages because are different. Yes.
Is to say what I don't want to do is say a percentage, because it isn't based on a flat percentage in Spain at all. It's actually based on scaled tables, and this is also dependent on which autonomous region of Spain, what the relationship of the person is to the deceased, and what the amount of the inherited estate is going to be. So it isn't a case of saying, right, it's X percent. We have to have all of this information and then base it through the tables in order to see if there is any inheritance tax due, and if it is, how much that was going to be in that specific case.
Is that a role of a lawyer like yourself to pay that and collect the customer's funds and pay it, or how do you go about that?
Well, the liquidation of the tax is a standard form within the tax office, which obviously as lawyers we're able to complete for you, and then you can just transfer the money directly to the tax office for this payment. We like our preference always with all of our transactions is that everything goes through the name of the client. So rather than them paying us provisions of funds, we arrange for all of the models so that the client is directly paying everything. So it's all always very clear and transparent.
Yeah, it's important to clarify that this step has to be done. Doesn't matter if the state is sent of the tax. So you have to submit the liquidation of the inheritance taxes. Doesn't matter if you have to pay the taxes or not.
Okay, and you mentioned, I mean, I have got a few questions from the audience. You have mentioned the NIE during the stage. What about the children? Are the children required to have NIE as well?
I mean, the problem is here. You need to sorry, the NIE is important to register the properties in their names and everything. So if the children are minors, is not, but they will need in the future. So obviously, we always recommend to proceed with this kind of process.
Okay.
In reality, obtaining the NIE number isn't an extremely complicated thing to do. There's lots of ways in order to do that. So I mean, if you think in terms of identification in the UK, you don't have identity cards for identification. You've only got passports, and passport numbers change. So the idea, the additional idea of the NIE number is that it's got specific identification to the person that it's related to.
Okay. So this, you mentioned always have a will beforehand to prevent some of these complications happening. We have got a listener today who is asking whether you would advise to buy a property in the name of the limited company or have a Spanish legal entity to pass the property to a family member.
It is something that we get asked quite often. I had a conversation with one of our senior lawyers about it this week. And the thing is, if you buy in the name of a company, you also have to then pay company taxes in Spain. You will have to pay quarterly and annual taxes and other charges for having a company. So in reality, unless you've got a large number of properties or assets that you're wanting to include, if it's just 2 or 3 properties, 1, 2 or 3 properties, it's usually better to do it straight into the name of a person. The other implication also is when it's done with a company, effectively the heirs are receiving shares, which is dealt with differently as well.
Okay, so one property, slightly different potentially advice or consideration, shall we say. So we, leading to my question in my head, how does it differ inheritance tax if I was owning a property in Spain as my permanent home or versus if it was just my holiday home? Because obviously that changes the nature of what's who I am and what's inherited. So can you explain the differences and if there are any?
Yeah. Yeah, Alma.
I was going to say, Christina, did you want to take that, or do you want me to?
No, it's fine.
Okay, it's a repeat of what we've just said. Inheritance tax is based on the area purchased, the amount of the estate, the relationship to the heir. It isn't based on residency, so it doesn't matter what the property was purchased for in that respect.
Okay, got a couple of questions from the audience as well. Is it true that the process of inheritance or a property transfer must take no longer than 6 months?
Yes. I mean, this is true, but you could extend 6 months more, so at least you will have 1 year. I mean, we always recommend to extend it because as are 2 different countries, everything is difficult after your parent or someone pass away. Obviously, we always recommend to the first step is extend the period, because obviously 6 months is not too much to proceed with everything.
Okay, thank you. Now, if somebody has got one child or a daughter that would inherit this property, is it advisable that they actually buy it with them? So, or just buy it in their own name and then have a will?
It's entirely dependent on what people want to do in their circumstances. When an inheritance procedure is going through, the thing to remember is the inherited part is just the part on the person that's deceased. So, for example, if you've got a husband and wife and 2 children, which are all written on the deed, effectively they all own a quarter of it. So if one person dies, then it's that quarter will be divided between the other 3, assuming that that's the way that it's been set up.
Okay, excellent. I hope we answered that question. That was from our live audience. I had this. I did another webinar for France on inheritance tax. These are very similar questions. If you own a property in joint names and one dies, does this cause any legal requirements before selling?
It does have to be adjudicated into the name of the heir before you can sell it.
Okay.
So, I mean, it's quite a common thing to happen in Spain, where we do an inheritance process followed directly with a sales process, where the partner that's left behind doesn't want to keep hold of the property and wants to sell it on. We have to, you know, we can tie the two together so that they almost flow one into the other. But they do have to be signed one before the next. Actually, I would like to make an important point, if that's okay. I don't know if it's going to come up, about the importance of making a Spanish will in the first place in terms of heirs, because for people that are resident and under European guidance, the law for the heirs is different to what you're used to in the UK. Now, this is not a problem for people in the UK. You can set the will up as you want it, but you do specifically need to put within the will to say that I wish to use the law in relation to my nationality, which is British. And then you can specify exactly how that would be, because I'm sure there's lots of people that have heard about how things are divided differently, where it goes into thirds, and you have a third that you can do for one and a third goes to the children. If you've got specific wishes, you just have to specify within the will how you want it to be set up, and then you can do that.
I think there were quite a few questions that were asked about that. So if you have another will outside of Spain, is it possible to arrange the inheritance in the country where this will is registered? So I think a lot of people will have this point and a question as well to ask. But in terms of paying the actual tax, is there a deadline? You know, because we all know that the tax are really quickly collected in many countries, and as soon as you are due, you don't want to miss that deadline. So is there a deadline that we should be aware of?
Yeah, it's the same deadline. I mean, we have 6 months to submit everything. So, but yes, if we extend the deadline, you will have one year. But yes, it's the same deadline. I mean, you have to declare everything before the 6 months.
So the point is it's supposed to be 6 months, and after that, then the taxes could potentially start increasing. But if you have registered with the tax office that you are in process and apply for that deadline, then that 6 months gets extended.
Okay.
It's just a case of keeping the tax office apprised that it's being dealt with and it's going to be sorted out.
Great. We've got back to the wills. I'm trying to not jump around because we've got loads of questions, and it's great. We've got a really engaged audience today. So Spanish will basically refers to the UK will as being definitive if you got the clause, if you are prepared, right?
It's still a Spanish will, but it's done, the heirs are according to how the British person wants to set them out, rather than the European or Spanish normal way of setting up wills. And for example, the norm in the UK for a husband and wife is it passes from one to the other, and there's no process required for it. Whereas in Spain, it isn't just passed to spouse, and it's automatically partially to the children and partially that you can choose. So that's what you're actually doing.
I think it's very similar in most of European countries. It is, you know, the kids are almost equal to spouse.
Yeah. The only ones that are different are UK and I think US as well. Where you?
Would you say we've got somebody joining us from Belgium? Is there a big difference? So you think Belgium falls under traditional European laws? In terms of, is there a big difference with the UK when it comes to wills and being in Spain and inheriting something in Spain?
Do you mean Spanish and Belgium?
No, we've got somebody who is living in Belgium at the moment.
Oh, okay. So sorry.
No, basically, whatever the law is in that country, it comes under EU regulations then, doesn't it?
Yeah. Okay, so I asked that question. We've got a few other questions. Lots of questions related to NIE. And because this is... we have property buyers who are preparing and are on this exciting journey, and they want this kind of really sort this out and be prepared for whatever circumstances. Do you apply for NIE before you buy a property?
You must. Basically,
even if you haven't found the property yet?
Yeah, I mean, you need
you can do it during, but you have to have it before it's signed.
Okay. You can't buy a property or a car, as you said, without having an NIE.
The final signing, you will need the NIE number for.
Yeah, it's because it's your identification number in Spain, so that's the reason you will need it for everything.
If we pay inheritance tax on the property in Spain, are we still liable for inheritance tax in Britain, or does that fall under the treaty? You just pay it in one country.
Yeah.
You have to
double
pay the
taxation.
taxes, where the property is. If the property is in UK, you must pay the taxes in UK, and if you have the property in Spain, obviously you have to pay the inheritance taxes in Spain.
Also, there is a question. I'm going to probably anonymize it and make it slightly less personal, but I just want to highlight to all of our viewers, inheritance tax is a very personal matter, and it depends on your personal circumstances and nationalities and who lives where as well, and having a will in place before something like this happens. But we have a viewer who's inherited money in Spain. Is money subject to tax, inheritance tax in Spain, if they were in a bank account?
Yes, I mean the full estate you have to pay the inheritance taxes for the full estate. Doesn't matter if it's cash, investment, properties, cars. I mean whatever you have to. I mean you have to pay for the whole estate. Doesn't matter if the assets are different.
Okay, excellent. So I think I've answered majority of the questions that we had today. We do have time to talk about 90 and 180 days. Even though we have covered this topic and we've got loads of content on it, I think people would like a really straightforward explanation on that, even though it does not necessarily fall under inheritance taxes. We do have this question, and since you guys are lawyers and know this topic, do you mind just giving us an idea? This is specifically for non-Schengen, therefore British.
There's no problem at all. The thing is, at the end of the day, all of these things are actually linked, because it's when people are talking about purchasing in Spain, whether it's going to be for a holiday home or for residency. And we do talk about the 90 and 180 days a great deal. The simplest way that I can say it is basically this. You have, from the day that you arrive in Spain, you set a clock. And that clock lasts for 180 days. Doesn't matter when it is during the year, but you then have 180 days period. During that period, you can use up to 90 days. You can use the full 90 days. You can use a portion of the 90 days. You can do it all in one go. You can do it in weekends until it's run out. It doesn't matter. But once you have used those 90 days up, or when you reach the 180 days, the next the 90 days, you have to leave Spain if you reach that. And you can't return until the end of that 180-day period that you started. Then the next time you come to Spain, whether it's the day afterwards or whether it's 6 months later, you start the clock again on another 180 days, during which you can have 90 days. Does that make sense?
Yes, it does. Thank you. Question about are Spanish residents legally obliged to have a will in place?
It's not legal obligation. It's recommended, and we would always recommend, if you've got assets in Spain, to make a Spanish will to cover the assets just in Spain. It makes it quicker, simpler, cheaper, and a lot easier for those left behind to deal with.
Okay, that's fine. I think that was one of the questions I might have missed. I apologize from all the questions that are coming through. Also, there is inheritance tax in Spain. What if you have assets in the UK and you are residing in Spain and something happens to you? Do UK assets become subject to Spanish inheritance tax?
We would normally say, if you've got UK assets, have a UK will to cover them. If you have Spain assets, a Spanish will. US assets, have a will over there. Have a will in each of those places to cover specifically those assets, and then you can avoid all of the additional expenses and complications.
Okay, another question related to a will, and then I will ask you about how to go about doing a will. I have a will in the UK. Do I need to do one in Spain? Because my husband has already died, but when I died, the estate will be split between our three and our 7 children. And if I buy a house in Spain in my name, will the inheritance be then still split between 7 ways? If the lady is asking, only 4 of these children are hers, but will it then be split to 7?
Well, this is her talking about buying a property.
Yeah.
It's exactly what we've just talked about. If she wants to set up a will, she can set up the will by her nationality and choosing which ones, how she wants to set that will up, and it will be applied in her Spanish will. But it needs to be specifically set up that way. If there is nothing, then you've got to go to either probate in the UK or the equivalent of probate in Spain. So this is one of the reasons that we think it's very important to do that Spanish will, to make sure that things are done according to what your wishes actually are.
Yes, it's important that the law that they will like to be applied has to be chosen in that will. So it's really important at that point.
And is that something you do as lawyers? So you obviously do conveyance, but do you do will as part of the conveyance? Do you do it afterwards, or what's the process of setting up the will?
We would normally set up afterwards. Once somebody has purchased a property, we give them the option to prepare the will. We will draft the will according to how they want it to be set out, and then arrange for it to be signed at a notary. The one thing that is important is a lot of things that we can do by power of attorney. The whole inheritance process we can complete by power of attorney with somebody in the UK, so they wouldn't have to come over. But for Spanish wills, they will actually need to attend a Spanish notary for that signing.
Okay. So one more, just to reiterate the question. My sons both live in Spain. My husband died in this country, has never lived in Spain, and has left some money to my sons. Will this money be subject to a tax if it goes to Spain?
If they are resident in Spain, they will already be doing annual income tax in Spain, la renta. This is based on your income, so it would become part of their income. So they wouldn't be taxed on it as an inheritance, but it would come under their general income.
Okay. The quick question about the stepchildren with a partner. Have they got same rights of your own children for inheritance? For instance, in Spain.
Sorry, could you please repeat the question?
The stepchildren. So if you are married second time, do they have the same rights as a partner, or as your own children?
We have to study this situation, because obviously it will depend if they are resident, if they are married. So we will have to study this particular situation. So if they would like to contact us, I will more happy to reply the question.
It's just to make sure that it's absolutely correct, because it depends very much on what their situation is and how they've got it set up.
Yes.
And the Spanish will, can you do it yourself and just have it and store it, or do you have to log it and register it?
It has to be notarized, and it is registered in the Spanish Registry of Wills. This is why right at the beginning, when we talked about the process and all these steps, is that we're actually applying for copies through these registry offices in Spain. It's a very formal process.
Okay, so you can't just write it on a piece of paper and then hope
it wouldn't be recognized. It wouldn't be recognized.
Okay, so it has to be official and it has to be filed according to the laws, and that's for it to be recognized at the time when something like this happens. Okay, I mean, we've got a few questions that are again about buying. So this is related to a survey, and if you buy a property with cash, do you still need to get the survey in Spain?
A survey is a choice that you have. I mean, from our point of view, we when we do a property purchase with our clients, we're very diligent on the searches that we do on the property to check the situation that it's in, with the town hall, if there's any infractions against it and such. But then it depends again, and with newer properties, you've got certain building guarantees which are already in place, like a 10-year building guarantee, which you might still be within. But if you're looking at a property which is much older, or depending on its physical situation, then it could well be a good idea to do a survey before you go ahead. So the survey is based on the property rather than how you buy it.
Okay. I'm going back to the taxes, and this is probably one of our last questions that we can ask, and then we can do key takeaways from this workshop, because I love running these masterclasses and workshops because there's so much information you wouldn't be able to just simply find by typing it into Google. And again, I must stress that this is really all about personal circumstances. So a lot of questions we get asked today, you can see that people have got their own life circumstances, and they need to be discussed properly in order to get it all right. But one question is, when you own a property in Spain but you are not a resident and you die, what about the taxes? Do they have to be paid in Spain or in your country? In the case it's Belgium.
On the property, it's a Spanish property that needs to be adjudicated to somebody and re-registered in the name of the heir, so it has to be done in Spain.
Yes.
So property taxes always to a country where it's where the property is. And 90-day rule. Last question. If you drive to Spain via France, does the 90 days start when you enter France or Spain?
France, it doesn't matter which country it is. One thing I didn't say earlier, when I was talking about the 90 and 180 days, that's 90 days in the whole of the Schengen area, the whole of Europe. You can't have 90 days in France and 90 days in Spain. Whichever of the Schengen countries you enter, your 180 days start and your 90 days end when you've used that time in whichever country that is.
We do have on your Overseas Home website, in on-demand section, Emma and JLCA lawyers have provided several webinars on explaining these rules. So all of you are welcome to simply log in there and watch any of the previous webinars that are explaining in the 30-40 minutes window and answering many variations of the 90 and 188 days. Are the previous sessions, and we will be running a session on this again, I believe, with Emma yourself in the coming months, because it is a topic that it's sometimes quite difficult to understand. There's so much being written about it, and cost-wise, obviously, nothing is free in this world. How much does it cost to set up a Spanish will?
Do you mean or fees or notary fees? I mean, there are lots of things involving.
Give us an idea of the fees of doing it with the lawyer and then registering it.
Typically, notary fees are 70 to 90 euros for notarizing a document. I think typically we would charge around 200 euros, 250 euros a person for arranging the will, but that's to draft it with you and make all of the arrangements to help you to get it signed. I think
but once again, not all the wills will be the same. So I understand that will depend of its kind of will, because sometimes some are difficult than others. So it will
just as sort of typically.
Yeah. So this is the basic one.
Yeah. The thing is as well is you don't use trusts in the same way that is used over in the UK. The Spanish wills generally, and as I say, Christina is quite rightly said, there's always exceptions when you've got a very complicated situation. But for the usual type of will, you would generalize all of your assets. So it's you may need to specify the property itself, but you don't need to say exactly what your bank account numbers are and everything. It's talking about your assets in general, rather than specifying it, and then to heirs rather than to trusts.
I was going to ask about the trusts not being recognised in Spain. So I think there is that consideration when you're writing a will, and you have wills in different countries potentially as well. So thank you very much for today. Really technical topic, really circumstantial. If people would like to get in touch with you, we will share your details as well on the email, but also if there is this content will again become on demand as soon as this webinar ends, so you're welcome to re-listen to it and look at the slides. The tax rate is a sliding scale then you must be aware of, and again it's calculated at the time, so we already discussed it earlier on, but is very, very different depending where in Spain you are. So that's a really big big point to make. Spain does not necessarily have a flood rate, and it's not like the UK. It's a really big differences. But thank you very much both today. I really enjoyed that. We had some great questions. Thank you very much to our audience, and we will see you next time for another masterclass or another workshop.
Yes, sir.
Thanks very
Thank
much,
you.
Jan.
Thank you.